The Constitutional Court has upheld a High Court ruling that found parts of the Regulation of Interception of Communication Act, that's the RICA Act, unconstitutional. Now, the ruling on Thursday has several implications, including that if surveillance is conducted on an individual, they must be told at some point afterwards. Now, the case was brought to court by the Amabungane Center for Investigative Journalism and is being hailed as a victory for media freedom, certainly. Amabungane managing partner Sam Soul says he was under surveillance back in 2017 when he investigated the NPA's decision to drop charges against former President Jacob Zuma. Let's get you more on the implications of this decision by the Constitutional Court. We're joined now by Jane Duncan, Professor of Journalism at the University of Johannesburg. Jane, good morning. Thanks very much for your time this morning. I mean, this is what the top line of the story is, that it is a victory for journalism because it makes it much more difficult for journalists now to be spied on.
I would agree with that, but I would go beyond that. I think it's a victory for lawyers because also the confidentiality of lawyers and the attorney-client privilege that attaches to that relationship is sacrosanct, and that could have been destroyed if the confidentiality of communications couldn't be guaranteed. But let's not restrict this victory to journalists and lawyers. It's a victory, I think, for broader society, because what it means is that unaccountable surveillance, where there isn't necessarily reasonable suspicion of a crime, is going to be that much more difficult for the spy agencies to be to undertake, not just in South Africa, but internationally as well. Because one of the implications of the judgment is that communications between South Africans and people outside the country will not be that easy to surveil anymore.
Yeah. I mean, on that score, there is a reason why the RICA Act ever came to be, you know, to keep better tabs on more nefarious activities. How does this decision affect the reasons, you know, what was one of the main reasons for bringing the RICA Act into being in the first place?
I think that we do need RICA. There's no doubt about that. And the Constitutional Court has confined itself to 6 particular areas of unconstitutionality. RICA is important, for instance, because it prevents our communications from being intercepted without a court order or what's called an interception direction from a designated judge. So that in itself, I think, is important. Setting out procedures for the grounds for the issuing of court orders or interception directions is extremely important. So I don't think that the overall objective of crime fighting and protecting national security is necessarily going to be weakened by this particular judgment. In fact, I think it's going to be strengthened. There is an area, however, that I think perhaps the State Security Agency may push back on, which is the fact that the National Communications Center, which undertakes what they refer to as signals intelligence surveillance, now really needs to be shut down until there's a law that establishes it. And the agency could argue that now they're naked, as some spies have been arguing in the past couple of days, that they are left naked by the disclosures that have happened at the Zondo Commission. Well, to the extent that that is the case, and other countries now have these powers, but we don't have these powers, I think they have only themselves to blame, because they have known since 2008 that the way that they've been conducting signals intelligence surveillance has been unlawful and unconstitutional, and they've failed to do anything about it.
I mean, what does this mean for our own ability to predict threats to our national security? Because I think you're talking about the issue of mass surveillance, you know, the State Security Agency using software to scan communications outside of the country to check whether there are any threats to South Africa's national security.
I think that there is certainly an operational argument for mass surveillance. So, for instance, if there is a buildup of troops on the border, it'd be relatively easy to pick up through signals intelligence surveillance because there would be anomalies in communications on the border. But I think that we need to separate out sharply the powers that are useful to an intelligence agency and the powers that we should grant an intelligence agency in a constitutional democracy. And while I concede that powers like this are useful, I think we need to find other ways of detecting threats and developing responses to those threats in the longer term, because I don't think it should be acceptable in a democracy for mass surveillance to be undertaken in any event, even if it's of communications that lie outside the border or that are passing through the Republic, because you are undertaking surveillance not on the basis of any kind of reasonable suspicion. You're scooping up huge amounts of information of innocent and potentially guilty people alike. And it's disproportionate to the task that you need to undertake as an agency to protect national security. We, for instance, wouldn't grant our agencies the power to undertake torture. And yet torture could potentially be, there is an argument about this, but could potentially be useful to our agencies in order as an investigative method. But no democracy worth its salt would want to grant that power to their agencies in a democracy. I see signals intelligence surveillance as being something similar. And if other countries still continue to enjoy these powers, then I think that South Africa should contribute towards the global fight that is very much underway at the moment to getting these kinds of powers outlawed.
Yeah.
Many cases internationally that are doing precisely that, particularly in the wake of the Edward Snowden revelations. And I think that South Africa should be making a contribution to those fights.
Professor Duncan, before we let you go, is this an opportunity for us to perhaps, now that parts of the RICA have been declared unconstitutional, to go back to the drawing board and to try and sort of re-look at what RICA should look like?
We absolutely need to go back to the drawing board, and that's exactly what the Constitutional Court has said. I was a little bit unsettled by the judgment yesterday that the Department of Justice has now been given 3 years, because RICA reforms have already been on their agenda for close to 4 years now. So it's possible that the entire cycle of reforming RICA will take in the region of 7 years, which I think is unacceptable. And I don't understand why the Department of Justice has been sleeping at the wheel when it comes to an act that it knows is problematic. Because if it wasn't problematic, it never would have embarked on a reform process in the first place.
Yeah, absolutely. I think a developing story, of course, that we'll continue to keep tabs on. Professor Jane Duncan, thanks very much for your time this morning. Such an interesting discussion. She is a journalism professor with the University of Johannesburg, as we continue to unpack the story unfolding in the Constitutional Court